Betsy McCaughey is the former Lieutenant Governor of New York. She is the author of Obama Health Law, What It Says and How to Overturn It. Betsy, is this court ruling the start of the unraveling of health care reform?
It may well be, yes. It's a very positive sign. Last November, House Speaker Nancy Pelosi was asked, is it constitutional to require Americans to buy a one-size-fits-all health plan? And she said, are you serious? Are you serious? Well, Judge Henry Hudson is saying it's time to get serious and apply the Constitution, something that Congress did not do before they passed this law.
Now, this is all about the mandate that you must buy health insurance.
Or pay a penalty.
Or pay a penalty. Now, if that is cut out, if for whatever reason it is cut out, does the health care reform plan collapse?
Yes, it could fall like a house of cards. Most complex legislation includes a boilerplate provision that says if one part of this law is struck down, other parts will remain enforceable. The authors of this law actually removed that boilerplate before the final version was passed, and both the deliberations about passing the law and even the court papers filed by the administration in this case suggest that they all agree this law cannot stand without this mandatory provision.
Now, what are states going to do as this legal situation is sorted out?
Well, this is very important because the states are already being pushed very hard to implement what are called insurance exchanges and put into place other costly changes to accommodate the Obama health law. Now you can bet that these states, which are very short on cash, are going to slow down those preparations, and that's going to be another bruising blow to this health law. A
bruising blow. Is it that serious?
Yes.
Is this a real setback for reform?
Oh, yes, because, first of all, Judge Henry Hudson has said, of course there are serious constitutional questions here. The administration all along made an argument that it was necessary to force people to buy insurance in order to spread the cost over more people and avoid people getting health care for free. But that's a ends justifies the means argument. And what Virginia did was to come in and make a constitutional argument saying, no matter how wise this public policy may be, it's not within the powers of the Constitution. The Virginia folks cited the Federalist Papers and 200 years of Supreme Court history saying the powers of Congress are limited, and it doesn't include forcing Americans to buy anything.
That's the legal fight. That's the constitutional fight.
Right.
Got it. Put that on one side for a second. There was a vote in Missouri.
The very next day, on Tuesday.
That's pure politics. That's the legislative
It wasn't pure politics. Excuse me, Stuart.
Oh.
It was the American people ignited to defend their freedom. And with the Constitution on their side, they believe they can do this. 71% of Missouri voters on Tuesday supported a proposition saying that residents of this state cannot be compelled to buy health insurance.
But that will be superimposed by federal law.
Well, you're arguing,
that's what I'm trying to say.
You're arguing the supremacy clause, but the fact is federal law is only supreme if it's constitutional. And in this case, many Americans believe and know that it is not. And in fact, that was at the heart of the Virginia case as well. Virginia passed a law called the Health Care Freedom Act saying no resident of the state of Virginia can be compelled to buy insurance. And 21 states are challenging the constitutionality of the Obama health law on those grounds. 5 states have passed something like the Health Care Freedom Act, and 3 other states have propositions up on the ballot just like the Missouri one.
You're piling it on, and you're real happy about this wrench in the works here, aren't you? You don't want health care reform, do you?
Well, I want everyone to have insurance. I want people to have good health care, but I don't want to see our constitutional rights shredded, and that's what the Obama health law does. First of all, it requires everyone to buy this one-size-fits-all plan, and enlarges the powers of the IRS to track you down and penalize you if you don't. But secondly, it also puts the government in charge of your health care for the first time. It says that insurance companies can pay only doctors who implement whatever regulations the Secretary of Health and Human Services thinks are good for health care quality. Well, that covers everything, it could cover things like whether you get a stent or a bypass, whether your OBGYN does a cesarean section, whether the president sees that end-of-life counseling made a mandatory part of health care.
Okay. If the current Supreme Court, the Roberts Court, were to adjudicate today on this issue, which way would it go?
It's hard to predict, but I can say that the constitutional argument to strike this down is very strong, because the administration claims that they have this power under the Commerce Clause. They have stretched the Interstate Commerce Clause like a rubber band, arguing that the decision of an individual not to buy insurance is interstate commerce.
And?
The decision not to do something is interstate commerce. And what Henry Hudson, the judge in Virginia, said, well, that's a pretty novel argument. We've got to have a trial on this one.
Betsy McCaughey, thank you very much indeed. We appreciate it.